Good morning, friends. Today we are going to deal with a very important area in administrative law. You know, administrative law is the law which deals with the executive branch of government. And the topic which we are going to deal with is rule against bias as a part of natural justice principles. Now, we are aware that government is divided into three branches. An ordinary government. സാധാരണ ഒരു ഗവൺമെന്റിന് 3 branches ഉണ്ടാവും. The three branches of the government are one, the legislature, which is made up of the parliament and the state legislative assembly. Secondly, the judiciary, which is made up of the Supreme Courts, the High Courts, and the subordinate courts. Then the executive branch. The third branch is the executive branch. Now, right from the ordinary civil police officer to the chief minister or prime minister of a state is a part of the executive branch. That branch is the branch which executes the law which is created by the legislature. ഒരു സർക്കാരിന് 3 ഭാഗങ്ങളാണ്. അതിലെ പ്രധാനപ്പെട്ട ഭാഗങ്ങളിൽ ഒന്നാണ് എക്സിക്യൂട്ടീവ്. സാധാരണ ഒരു പോലീസ് ഉദ്യോഗസ്ഥൻ മുതൽ ഒരു സ്റ്റേറ്റിലെ ചീഫ് മിനിസ്റ്റർ അല്ലെങ്കിൽ പ്രൈം മിനിസ്റ്റർ വരെയുള്ള എല്ലാ അംഗങ്ങളും ചേരുന്ന ഒരു ബോഡിയാണ് എക്സിക്യൂട്ടീവ്. അവരാണ് നിയമം നടത്തിയെടുക്കുന്നത്. They execute the law. Now, when the concept of the state changed in the modern period, that is the 20th century and 21st century, there was a shift from the concept of laissez-faire state to the welfare state. So when the concept of the government changed from the welfare to the welfare state, the power of the government increased. That is, the government started doing so many different roles which were not present in the early form of governments. The early form of government means the laissez-faire government. So when the power of the government increased, it is the power of the one branch of government which is increased, and that is the executive branch of government. So their powers, the power of the executive branch, increased many folds. നമ്മുടെ പുതിയ കാലഘട്ടത്തിൽ സർക്കാരിൻ്റെ അധികാരങ്ങൾ വർദ്ധിച്ചു. സർക്കാരിൻ്റെ അധികാരങ്ങൾ വർദ്ധിച്ചപ്പോൾ ഇതിനകത്ത് എക്സിക്യൂട്ടീവ് ബ്രാഞ്ചിൻ്റെ അധികാരമാണ് കൂടുതലായിട്ട് വർദ്ധിച്ചത്. ബാക്കി 2 ബ്രാഞ്ചസിനും അധികാരം കൂടി, പക്ഷെ അത് നോമിനലായിട്ടേ കൂടിയുള്ളൂ. So the power of the executive branch increased many-fold. Now the executive branch started doing the function of the legislature, and the executive branch started doing the function of the judiciary. Now, the executive branch doing the function of the legislature is called by the name delegated legislation. And the executive branch doing the function of the judiciary is often termed as the quasi judicial functions. Now, what is quasi judicial functions? Now, quasi judicial functions can be termed as certain functions which are now being done by the executive, which in the earlier period was considered to be the region or the area of the courts, or these functions were earlier done only by the courts. Now it is being done by the executive. പഴയ കാലത്ത് കോടതികൾ മാത്രം ചെയ്തുകൊണ്ടിരുന്ന പല ഫങ്ഷൻസും ഇപ്പോൾ എക്സിക്യൂട്ടീവാണ് ചെയ്യുന്നത്. അങ്ങനെ എക്സിക്യൂട്ടീവ് ചെയ്യുന്ന ഫങ്ഷൻസിനെയാണ് നമ്മൾ ക്വസൈ ജുഡീഷ്യൽ ഫങ്ഷൻ എന്ന് പറയുന്നത്. Now, an example for a quasi judicial function is that, a particular person in government service commits some misconduct, and for that misconduct a service inquiry is done, and this particular person is suspended or dismissed from the service. Now, earlier this function could have been done only by the courts. Now who is doing that? Now it is being done by the executive. Executive means the executive branch, the executive government. So this is one example. Another example, that particular child, student, he commits a malpractice in an examination. Now, if for this malpractice, an inquiry is committed by the syndicate of the university and he is debarred. Now, earlier this function also could have been done only by the courts. Now it is also being done by the executive. Now these are two examples where you can see that the executive is doing functions of judicial nature, that is disputes. പഴയ കാലത്ത് ഇപ്പോൾ നമ്മൾ ഉദാഹരണങ്ങൾ എടുത്തു കഴിഞ്ഞാൽ, പണ്ട് ഒരു കുട്ടിയെ കൊപ്പയടിച്ച് പിടിച്ചു കഴിഞ്ഞാൽ അയാളെ ഇപ്പോഴും സിൻഡിക്കേറ്റ് കമ്മിറ്റി എൻക്വയറി നടത്തി പുറത്താക്കും. പണ്ട് ഇതൊക്കെ കോടതിക്ക് ചെയ്യാൻ പറ്റുള്ളായിരുന്നു. അതേമാതിരി ഒരു സർക്കാർ ഉദ്യോഗസ്ഥൻ എന്തെങ്കിലും ഒരു മിസ്കോണ്ടക്ട് നടത്തി, ഇപ്പോഴാണെങ്കിൽ അയാളെ സർക്കാർ തന്നെ എൻക്വയറി നടത്തിയിട്ട് പുറത്താക്കുകയോ സസ്പെൻഡ് ചെയ്യുകയോ ചെയ്യും. പണ്ട് അങ്ങനെയല്ല. ഇറ്റ് ക്യാൻ ബി ഡൺ ഓൺലി ബൈ ദ കോർട്സ്. സോ ദീസ് ടൈപ്പ് ഓഫ് ഫങ്ഷൻസ് ആർ termed as quasi judicial functions. Now, one drawback of the quasi judicial function is that, see, when an activity is or when a procedure is happening in a court, there are strict procedures to be followed. There are inbuilt security system. That is, if it is a civil court, you have to follow the procedure of the civil procedure code. If that is a criminal procedure, you have to follow the CRPC. So if something is happening in a court, a strict procedure has to be followed. But when a quasi judicial function is being done, one drawback is that there is no strict procedure, rules or provisions of how the things should be conducted. There can be certain rules, but there is no strict procedure as to how a quasi judicial function has to be done. അപ്പോൾ ഒരു quasi judicial function നിർവഹിക്കുമ്പോൾ കോടതിയെ പോലെ കൃത്യമായ റൂൾസോ പ്രൊസീജിയറോ ഒന്നും കാണണമെന്നില്ല. അത് അതിൻ്റെ ഒരു ന്യൂനതയാണ്. Now in quasi judicial functions, to certain extent, to avoid this sort of problems, the law has come with certain principles. So in quasi judicial functions, certain principles are to be followed by the authority, the judge, the administrative authority. Quasi judicial functions ചെയ്യുമ്പോൾ ജഡ്ജ് അല്ലെങ്കിൽ അഡ്മിനിസ്ട്രേറ്റീവ് അതോറിറ്റി ചില പ്രിൻസിപ്പിൾസ് ഫോളോ ചെയ്യണം. No, these principles are called by the name natural justice principles. So natural justice principles are principles that are to be adopted and followed in a quasi judicial function. So whenever a quasi judicial function is being done by a judge or an administrative authority, these fundamental principles called natural justice have to be followed. Now we know that there are so many principles of natural justice. But in administrative law, there are two principles which are very fundamental. These two fundamental principles of natural justice are: one, rule against bias. One, rule against bias. And two, right to fair hearing, or audi, alterum, partem. So two basic natural justice principles are: one, rule against bias, and secondly, audi, alterum, partem. So in today's video, we'll be dealing only with the rule against bias. Now we'll start with the rule against bias. What is rule against bias? Rule against bias means when a judge or an administrative authority is deciding a case means a quasi judicial matter, then there should not be any affinity, there should not be any prejudice, there should not be any any form of a bias on the part of the judge towards the parties of the issue or the subject of the issue. ഒരു quasi judicial function ഒരു ജഡ്ജി അല്ലെങ്കിൽ ഒരു അഡ്മിനിസ്ട്രേറ്റീവ് അതോറിറ്റി നടത്തുമ്പോൾ അതിലെ പാർട്ടീസിനോടോ അതിലെ വിഷയത്തിനോടോ ആ ജഡ്ജിന് ഒരു തരത്തിലുള്ള താല്പര്യവും പാടില്ല. താല്പര്യം എന്ന് പറഞ്ഞാൽ മമതയാവാം, വിരോധമാകാം, എന്തുമാകാം. So there should not be any sort of relationship, any sort of prejudice, any sort of affinity for the judge who determines and the parties or the subject matter of the case. This is a basic principle of natural justice. So this is called the rule against bias. Now, rule against bias is based upon three maxims. Maxims, maxims are sayings in law or beliefs in law. Now, what is the first maxim? That is, with regard to rule against bias, there are certain maxims which are considered to be the force behind. The first maxim is nemo judex in causa sua. Nemo judex in causa sua means no one should be a judge in his own cause. No one should be a judge in his own cause. സ്വന്തം കാര്യത്തിന് ഒരാള് ജഡ്ജിയാകാൻ പാടില്ല. അർത്ഥം, വളരെ താല്പര്യമുള്ള കാര്യത്തിൽ ഒരാൾ ജഡ്ജിയായിട്ടിരിക്കാൻ പാടില്ല. So that is the first maxim. Second maxim is justice should not only be done but should manifestly be seen to be done. Justice should not only be done but it should be manifestly be seen to be done. ന്യായം കൊടുത്താൽ പോരാ, കൊടുക്കുന്നതായി തോന്നുകയും വേണം. നമ്മൾ ഒരാൾക്ക് ന്യായം കൊടുക്കുമ്പോൾ ന്യായം കൊടുക്കാതിരിക്കട്ടെ, പക്ഷെ പുറത്തുനിന്ന് നോക്കുന്നവർക്ക് തോന്നണം അവിടെ ന്യായമാണ് കിട്ടുന്നത്. അതാണ് രണ്ടാമത്തെ മാക്സിം. The third is the Caesar's wife should be above suspicion. Caesar's wife should be above suspicion. സീസറുടെ ഭാര്യ സംശയത്തിനുപരിയായിരിക്കണം. അതായത് സംശയം ഉണ്ടാകുന്ന ഒരു സാഹചര്യത്തിൽ പോലും സീസറുടെ ഭാര്യ എന്ന് പറയുന്നത് രാജാവ് അല്ലെങ്കിൽ രാജ്ഞി എന്ന് സൂചിപ്പിക്കുന്നു. അങ്ങനെ സീസറുടെ ഭാര്യ ഒരു സംശയം ഉണ്ടാക്കുന്ന സാഹചര്യത്തിൽ പോലും ചെന്നുപെടാൻ പാടില്ല. So these are the three maxims on basis of which we have this principle of rule against bias. That is, no one should be a judge in his own cause. Now, this rule against bias can broadly be classified into three. What are the three types of bias? The three types of bias are: one, pecuniary bias; the second is personal bias; and the third is official bias or subject matter bias. These are the three types of bias. Bias മൂന്നായിട്ട് തിരിച്ചു: personal bias, pecuniary bias, official or subject matter bias. Now, first is pecuniary bias. Now, what is pecuniary? pecuniary means something connected with finance. സമ്പത്തുമായി ബന്ധപ്പെട്ടത്. അതാണ് pecuniary. So pecuniary means the judge or the administrative authority who decides a quasi judicial function should not be financially having any affinity or relationship between the parties in front of him or the subject in front of him. So there should not be any financial relationship. For example, the judge who decides a case, he has taken a huge loan from the party whose case he has to decide. തീരുമാനമെടുക്കേണ്ട ജഡ്ജ് പാർട്ടിയുടെ കയ്യിൽ നിന്നൊരു വലിയ തുക കടം മേടിച്ചിട്ടുണ്ട്. Then there is a possibility that his decision will be biased. Even though he is not biased, people may say that there is some sort of an affinity. It should not happen. So there should not be any financial relationship with the judge who decides the case and also the party in front of him or the subject in front of him. This is called the pecuniary bias. Now let's study two cases with regard to pecuniary bias, earlier English cases. There are so many new cases, but we are focusing on only the classic cases. The first case is Bonham's case. Bonham, Bonham's case, Dr. Bonham's case. This case happens, I think, in the 17th century. Very ancient case that is happening in England. Now there was a doctor of the Cambridge School of Medicine, Cambridge University. Now this doctor, what happened, this doctor, against the rule of the university, practiced in the city of London. Cambridge School of Law, അല്ലെങ്കിൽ കേംബ്രിഡ്ജ് യൂണിവേഴ്സിറ്റിയിലെ ഒരു ഡോക്ടർ യൂണിവേഴ്സിറ്റിയുടെ റൂളിന് അഗേൻസ്റ്റ് ആയിട്ട് ലണ്ടനിൽ പ്രാക്ടീസ് ചെയ്യും. No, this was a what do you call misdemeanor. This was against the law, and therefore the university conducted an inquiry and fined the doctor because it was against their rules of the university. So they conducted an inquiry and fined the doctor, put a huge amount as fine. As per the existing law, half of the fine will go to the university and half of the fine will go to the government. But university doctor fine ചെയ്തു, ഫൈൻ ചെയ്ത തുകയിൽ പകുതി യൂണിവേഴ്സിറ്റിക്ക് പോകും, പകുതി ഗവൺമെന്റിന് പോകും. This determination of the university was challenged. On challenge, the court held that here the university is fining and the amount of fine, a huge sum of the amount of the fine is going to the university itself. So this is an issue where the university is having a pecuniary interest. As the university has a pecuniary interest, this decision is bad. അപ്പോൾ കിട്ടുന്ന പൈസ പകുതി യൂണിവേഴ്സിറ്റിക്ക് പോകുമ്പോൾ അവർക്ക് അതിനകത്തൊരു സാമ്പത്തിക താല്പര്യമുണ്ട്. So the court held that there is a case of pecuniary bias and the decision is bad. This is the Bonham's case, one of the earliest cases. Now there is second case, again an English case, that is Dimes versus Grand Canal Junction Company. Dimes versus Grand Canal Junction Company. Now in this case, what was the fact? Now there was a Lord Chancellor. Lord Chancellor is something like the minister. Ividuthe minister poleയാണ്. Lord Chancellor means something like a minister. The Lord Chancellor had to decide a case. It was with regard to a company called Grand Canal Junction Company. He was the judge and he was to decide the case. And the Lord Chancellor decided the case with regard to Grand Canal Junction Company. Against that decision, an appeal was filed. The main contention again in the appeal was that chancellor who decided the case is a shareholder of the company against whom the decision is made. So the chancellor who decided in respect to a company is also a shareholder of the company. So there is a probability for what? There is a probability for bias. So it was challenged. So on appeal, the law lords, that is the judges of the appellate court, when they scrutinized the case, they found that the chancellor was in no way biased. The chancellor was in no way biased. But even then, they quashed the case. You know why? Because of the principle that justice should not only be done, but should manifestly be seen to be done. അപ്പോൾ ഇത് തീരുമാനിച്ച ജഡ്ജ് ഒരു കേസ് ഒരു ജഡ്ജ് തീരുമാനിച്ചു ഒരു കമ്പനിക്കെതിരെ, ആ കമ്പനിയുടെ ഷെയർ ഹോൾഡറാണ് ജഡ്ജ്. അതുകൊണ്ട് അതിനെതിരെ കേസ് പോയപ്പോൾ കോടതി മനസ്സിലാക്കിയത് ഈ ജഡ്ജ് ഒരു തരത്തിലും ഒരു ബയസ് കാണിച്ചിട്ടില്ല. ബയസ് കാണിച്ചിട്ടില്ലെങ്കിൽ പോലും കോടതി തീരുമാനം അസാധുവാക്കി. എന്താണെന്നറിയോ? ന്യായം കൊടുത്താൽ മാത്രം പോരാ, കൊടുക്കുന്നതായിട്ട് തോന്നണം. അപ്പൊ ഷെയർ ഹോൾഡർ ആയിട്ടുള്ള ജഡ്ജ് തീരുമാനിച്ചു കഴിഞ്ഞാൽ ആളുകളെങ്കിലും പറയും, ഓ അത് ജഡ്ജും മറ്റേവരും ഷെയർ ഹോൾഡറും കമ്പനിയൊക്കെ തന്നെയെന്ന് ഒരു സംശയം പറയും. So on the basis of the principle that justice should not only be done, should be manifestly be seen to be done, that decision was quashed. So these are the two matters with regard to what you call pecuniary bias. Now we come to personal bias. Now what do you mean by personal bias? Personal bias means the judge who decides the case or the administrative authority who decides the case is having some sort of a personal relationship between the party in front of him. തീരുമാനിക്കുന്ന ജഡ്ജിയും തന്റെ മുമ്പിലുള്ള പാർട്ടിയുമായിട്ട് വ്യക്തിപരമായിട്ടുള്ള ബന്ധം. Just like a father is deciding a matter with regard to a son. A malpractice is being alleged against a son in an examination, and the syndicate committee is headed by the father of the student. പരീക്ഷയ്ക്ക് കോപ്പി അടിച്ച കേസിന്റെ അന്വേഷിക്കുന്ന കമ്മിറ്റി ഈ കോപ്പി അടിച്ച പയ്യന്റെ അച്ഛനാണ് ആ കമ്മിറ്റിയുടെ ചെയർമാൻ. So there is, see, personal affinity or personal bias can happen when there is a relationship between a father and a son, husband and a wife, other relatives. Judge is the father and the party is the son. It can also happen in case of a negative bias. That is, when a judge who decides a case, he is a great enemy of the party in front of him. They have continuously argued and filed cases between each other. In such cases also there is a probability of a bias. Personal bias എന്ന് പറഞ്ഞാൽ വ്യക്തിപരമായ താല്പര്യം ജഡ്ജിയും ഫ്രണ്ടിലുള്ള പാർട്ടിയുമായി. ഈ താല്പര്യം എന്ന് പറയുന്നത് നല്ലതും ആവാം ചീത്തയാവാം. ഒരു ജഡ്ജിയുടെ ബന്ധുവാണ് പാർട്ടിയെങ്കിലും ബയസ് വരാം, ഒരു ജഡ്ജിയുടെ ശത്രുവാണ് പാർട്ടിയെങ്കിലും ബയസ് വരാം. So both this type of relationship between the judge who decides and the party in a case, personal relationship, that is called the personal bias. Personal bias. Now we can illustrate the particular aspect of personal bias with two classic cases, only two classic cases. You can yourself go and find out new cases and keep on adding it. I am just dealing only with the basic cases. The first case is Kraipak versus state. Kraipak, Kraipak versus Union of India. Kraipak versus Union of India. No, it's a very interesting case. There was an interview for the post of Chief Conservator of Forest. That is a cadre of the All India Forest Service. Now there was an interview board to conduct the interview. The post for selecting a person as the Chief Conservator of the Forest. A deputy conservator of forest who was acting as the conservator of forest was a member of the interview board. So a deputy conservator of the forest was also a member of the interview board. And this conservator was also an applicant for the post. That is, a person who is in the interview board itself is an applicant in that for that particular post. So what will happen when his name is called? He will step down from the interview board and then he will face the interview board. ഒരു പോസ്റ്റിലേക്കുള്ള ഇന്റർവ്യൂ ബോർഡിലുള്ള ഒരു അംഗം തന്നെ അതിന്റെ പോസ്റ്റിൽ അപ്ലൈ ചെയ്തിട്ടുള്ള ഒരാളാണ്. അപ്പൊ അയാളുടെ പേര് വിളിക്കുമ്പോൾ ബോഡിയിൽ നിന്ന് ഇറക്കി താഴെ വന്ന് ഇന്റർവ്യൂ ബോർഡിന് ഫേസ്. So here it is a clear case of what a person is judging his own case. When the case came before the court of law, the contention of the person was with regard to his interview, he did not deliberate. That is, he did not put mark for his interview. Only the other members put mark. But obviously what will happen? How will be? He is there with regard to evaluating all other persons. പുള്ളിയുടെ കണ്ടൻഷൻ എന്താന്ന് പറഞ്ഞാൽ എന്റെ ഇന്റർവ്യൂവിന്റെ സമയത്ത് ഞാൻ മാർക്ക് ഇട്ടില്ല, അത് അവരായിട്ടത്, പക്ഷെ അയാൾ മാർക്ക് ഇടണ്ടല്ലോ. So see, imagine a person who is an applicant for an interview board, for an interview, himself is a part of interview board. This is the classic case of a person being a judge in his own cause. So obviously the decision was held invalid. This is one case. Second case is with regard to a negative bias. That is the case of State of UP versus Mohamad Nooh. State of UP versus Mohamad Nooh. Now in State of UP versus Mohamad Nooh, the fact is like this. There was a service inquiry against a police officer. The inquiry was being conducted by the deputy superintendent of police. He was conducting the inquiry. Now the DYSP was sitting on a platform as an inquiry officer, and the other persons were there. Now when the witnesses gave depositions against the civil police officer, against the civil police officer, he was not satisfied. Against the civil police officer, he was not satisfied. That is, the inquiry officer was not satisfied with regard to the way the witnesses were giving testimonies. He got infuriated. So the DYSP stepped down. The DYSP stepped down from his chair, went to the went to the box of the witnesses, gave statement as a witness. അപ്പോൾ എൻക്വയറി നടത്തിയിരുന്ന ഈ എൻക്വയറി ഓഫീസർ, പോലീസുകാരൻ, അയാൾ താഴെ ഇറങ്ങി സാക്ഷിയായിട്ട് സാക്ഷിമൊഴി കൊടുത്തു. And on the basis of the deposition given by the police officer, the inquiry officer, he later came and decided the case. അപ്പോൾ ഒന്ന് നോക്കിക്കേ, ഒരു ഡിവൈഎസ്പി തെളിവ് കൊടുക്കുന്നത് ഇഷ്ടപ്പെടാതെ, എൻക്വയറി ഓഫീസർ ആയിട്ടുള്ള ഡിവൈഎസ്പി തെളിവ് കൊടുക്കുന്നത് ഇഷ്ടപ്പെടാതെ താഴെ ഇറങ്ങി വന്നിട്ട് അയാൾ സ്വയമായിട്ട് സാക്ഷി ആയി നിന്ന് സാക്ഷി മൊഴി കൊടുത്തിട്ട് ആ മൊഴിയെ ബേസ് ചെയ്തിട്ട് the police officer was punished. So this clearly shows enmity on the part of the inquiry officer against the police officer. So the court quashed that because it is obviously a case of personal bias, personal enmity. So that is the second bias, the case of personal bias. Now the third category is an interesting category, that is a subject matter bias or an official bias. Now what is an official bias? In official bias, The judge or the administrative authority who decides the case, he does not have any personal affinity or hatred towards the parties. He doesn't have any pecuniary interest towards the parties. But the thing is that he is having an official bias. See, certain officers of the government will be having some sort of an affinity towards certain governmental policies, and they will be liking certain subject, and they have some sort of affinity officially. അതായത് തീരുമാനിക്കുന്ന ജഡ്ജിന് ആ വിഷയവുമായിട്ട് ഒരു ഡിപ്പാർട്ട്മെന്റൽ താല്പര്യം. So he has some sort of affinity officially. This is also called by the name departmental bias. That is, the judge has a departmental or official bias towards the issue in front of it. This is called a subject matter bias. അല്ലാതെ ജഡ്ജിക്ക് സാമ്പത്തികമായോ അല്ലോ പേഴ്സണൽ ആയിട്ടുള്ള മമതയല്ല, ഒരു പ്രത്യേക ഒഫീഷ്യൽ ആയിട്ടുള്ള ഒരു മമത വിഷയമായിട്ട്. We can clarify this with two cases. Incidentally, the name of the cases are same, but two different cases. The first case is Gullapally Nageswara Rao versus APSRTC, case number 1. Gullapally Nageswara Rao versus Andhra Pradesh State Road Transport Corporation, case number 1. Now, what is the case? Now, in Andhra Pradesh, the government mooted an idea to nationalize the bus service. That is, once the bus service is nationalized, then the private buses will not be allowed to ply. So they mooted an idea. So before they nationalized or went with that particular policy, they constituted a committee to hear the grievances and objections of the private bus owners. Andhra Pradeshile ട്രാൻസ്പോർട്ട് സർവീസ് നാഷണലൈസ് ചെയ്യാനായിട്ട് തീരുമാനം എടുത്തപ്പോൾ പ്രൈവറ്റ് ബസ്സുകാർക്കുള്ള കംപ്ലൈന്റ് കേൾക്കാനായിട്ട് ഒരു കമ്മിറ്റി രൂപീകരിച്ചു. Now, in the committee, the main person in the committee was Secretary, State Road Transport Corporation. The Secretary of the Road Transport Corporation, Secretary Transport, not Road Transport Corporation. Secretary of Transport was the person who had to hear the objections. So after hearing the objection, he will decide whether to move with the nationalization to end it there. Now, it so happened that the Secretary Transport was the same person who was sitting as the person to hear the objection, was the same person who first mooted the idea of nationalizing buses. അപ്പം ഇതിൻ്റെ തർക്കം കേൾക്കാനായിട്ട് ഇരിക്കുന്ന ജഡ്ജിയായിട്ടിരിക്കുന്ന ഈ ട്രാൻസ്പോർട്ട് സെക്രട്ടറി തന്നെയാണ് ഇത് നാഷണലൈസ് ചെയ്യണമെന്ന് ആദ്യമായിട്ട് ഒരു ഐഡിയ കൊണ്ടുവന്നത്. So the person, what will be the thing? He will be having a very negative attitude with regard to the objections, because it is his idea to nationalize the business. So he will, overcome all the negatives from the private bus owners and their complaints. He will not pay heed to any of it. Well, that is obvious, because he is definitely having an official or departmental bias with regard to this policy. So, as it is a case of departmental bias, as it is a case of official bias, the court invalidated the decision of this particular secretary, the committee headed by the secretary. Now, this is Gullapally Nageswara Rao versus APSRTC 1. When the decision of the secretary was invalidated by the court, the government reconstituted the committee to hear objections of the private bus owners. And in the new committee, Minister of Transport was appointed as the authority. Instead of the Secretary Transport Department, Minister was appointed as the person to hear the objection. Now this committee also was challenged. The constitution of this committee was also challenged on the ground of bias. And that was in the second case, that is the case of Gullapally Nageshwar Rao versus APSRTC 2. So when the second committee from with transport headed by the transport minister came, it was challenged before the court on the ground of bias, because transport minister will be biased in favor of the public transport system. That was the challenge. This was not accepted by the court. Court held that unlike the Secretary of Transport, the minister is not a part of the government. In technical sense, minister is a part of the government. But minister owes responsibility both to the government and to the people. Because minister is an elected representative of the people. So he will be committed both to the people and also to the department. But he will not be having any bias towards the department. So if a minister is appointed to hear the objection, you cannot say that he will be biased in favor of the government alone. So on this ground, the court held that in the second case, when the minister is appointed as the person for hearing the objection, there is no case of bias. So these are only the basic cases and basic concept with regard to rule against bias. You can have umpteen number of cases, so many number of cases in this category. This is only the basic essential. Hope you like this video. Thank you so much.